Bonjour tout le monde. Good morning, everybody. I'm delighted to welcome you today for a new CLTS virtual talk. Je suis extrêmement heureux de vous accueillir aujourd'hui pour une nouvelle conférence virtuelle du CDTS et en si grand nombre. For those who don't know me, my name is Florian Martin-Bariteau. I am an associate professor and the University Research Chair in Technology and Society at the University of Ottawa, where I am also the director of the Center for Law, Technology, and Society. So thank you so much for being with us today for this virtual event, to our speakers and to the attendees. And we're like all together today because a week and 1 hour ago, after a lot of wait, some would say 20 years, others would be just like a few days, the Minister of Innovation, Science and Industry of Canada tabled the much awaited privacy reform for the private sector at the federal level. So Bill C-11, an act to enact the Consumer Privacy Protection Act, CPPA, and the Personal Information and Data Protection Tribunal Act, and to make consequential amendments. One of the biggest one is to repeal the part of PIPEDA that was about privacy, which might be maybe the best news with C-11, because in my opinion, PIPEDA was one of the worst written piece of federal legislation. And so today, to discuss those proposals, I have invited some of Canada's leading experts to comment on the bill. Not all of them, but still, like, we have nine experts today to discuss some of the specific details, the right, like the new compliance obligation for the corporations, the new tribunal, etc. Obviously, we will not be able to go through everything in just 1 hour and 30 minutes. It's a very long act, like hundreds of pages of exception to the rule. But we're gonna try to look more into this, and as I've been repeating again and again with CPPA and with the tribunal, like the devil is in the details. But we're gonna try to look into this today with our speakers. So the format of the event will be as follows. So first, I will invite our expert to share with us their hot takes in like 2-3 minutes, maybe 5 minutes maximum. And then we will have a Q&A, mostly based on the question that will be asked by the participants. And so for everybody who want to ask a question, I will invite you to use the conversation function, the chat. So there is someone on your screen, kind of a bubble button. So you can click on it. That will open the conversation. And so ask your question there. I'm expecting we're gonna have a lot of questions. So if you like one of those questions, I will invite you to like it, like to give it a thumbs up or like a love or whatever you want. This way that would help me to kind of filter the questions we will have during this event. And so without further ado, I will start up with that kind of roundtable with our experts. And maybe I will first invite my partner in crime in organizing that amazing event, Professor Teresa Scassa from the University of Ottawa. Teresa.
Thank you so much, Florian. And you know, if I'm the partner in crime, I'm really just the one hoping to profit from it, because Florian has done all the heavy lifting here. So let's be clear about that. But I'm really delighted to be here. I'm looking forward to hearing what the other panelists have to say about this bill. And thank you all for turning out in such large numbers for this. My first reaction to the bill was I'm very pleased that it is redrafted. In the way that it's redrafted, I think it looks like a much more mature data protection statute than it than it used to. But of course, one of the downsides is it's really hard to, there's because so much of the wording has been changed and because it's been restructured, it's really difficult to get a clear sense, a clear and immediate sense of what has changed. And sometimes there are new provisions which are easy to spot, and sometimes there are reworded provisions, and there's rewording that is actually quite interesting and significant. So I don't feel personally that I'm at the stage where I have a lot of very profound insights about the bill, but what I have been doing in the last few days is going through and looking at things that jump out at me as interesting. And I'm just going to flag one of these for you today, and then I'm going to sit back and listen to what everybody else has picked out, because I think that'll be very interesting as well. As you know, or as you may know, I've often I've written or spoken about the importance of approaching privacy as a human right. And I have been critical of this bill for not coming out up front and addressing privacy as a human right. There is a reference to the need to balance, and there always was in PIPEDA, the individual right to privacy with the needs of data to needs of organizations to collect and use data. But I think in our current data society and economy, it's really about acknowledging the profound individual, group, and social harms that can and do flow from the undue exploitation of personal data, including bias and discrimination, manipulation and exploitation, and even attempts to undermine public values, public health, democracy, and so on. And I think all of that needs to be acknowledged front and center in data protection law. It doesn't take a lot, but I think we have to address that it's not just about, you know, me and what control I have over my personal information, but it's about some of these bigger issues as well. That said, I find sections 12 and 13 in this bill really interesting, because in my view, sections 12 and 13 introduce necessity and proportionality approach to data collection, use, and disclosure, which is tends to be a hallmark of a human rights-based data protection regime. So I find those provisions interesting. Section 13 specifically says you can only collect what information is necessary. An organization can only collect information that's necessary. Section 12 talks about collecting, using, or disclosing personal information only for purposes that a reasonable person would consider appropriate in the circumstances. But then it goes on to set out criteria for evaluating the appropriateness of the collection, use, or disclosure of information. And those criteria really map onto a necessity and proportionality assessment. And so I find it very interesting that there's no upfront acknowledgement of privacy as a human rights-based approach, but there is this necessity and proportionality scheme in sections 12 and 13. I think that this is going to be a hot button issue for industry. I think there'll be a lot of pushback against sections 12 and 13 because I think they expose businesses to a much higher level of scrutiny for their information or data protection practices. And I'll just close my comments by saying that I was also, being a privacy nerd with clearly nothing else going on in her life right now, I was also reading the Department of Justice's discussion paper on reform of the Privacy Act. And I think you have to look at private sector data protection alongside public sector data protection reform because both are moving in the same direction, addressing similar issues, and also seeking to meet the adequacy assessment under the GDPR. And I think it's really interesting to note that in the Department of Justice's document, they actually step aside from necessity and proportionality as approach to data collection, and instead propose adopting the standard of the collection of data reasonably required to achieve a purpose rather than necessary. And so it seems that the Department of Justice is proposing a lower threshold for the collection of personal data in the public sector context than the Department of Industry is imposing on the private sector. And so I think that this this disjuncture here is very interesting as well. So I'm just going to flag that as something that's jumped out at me, and I'll stop there and pass the baton to the next speaker.
Yeah, thank you so much. And maybe because I know you insisted a lot, and on Twitter, a lot of you, I think, today followed like some of the tweets that Teresa and I did around the C-11, and you insisted a lot about like human rights, and I know it's something that the commissioner insisted in his report that he published like a few days before C-11. And so maybe I would call on Professor Ignacio Cofone from McGill, who authored a report on behalf of the Privacy Commission of Canada that was also released like a week before C-11. So maybe Ignacio, if you could share with us your hot takes and maybe what do you think about C-11 around like the rights that they give to citizens, etc.
Hi, thank you, Florian, and my apologies to everyone. My voice is almost gone, so I'm gonna get my mic close to myself and try to speak as loudly as possible. So thank you for organizing this, first of all. And answering your question, first of all, I think this is overall a wonderful bill, and it's unequivocally an enormous improvement from PIPEDA, as Teresa was explaining. In terms of the rights that individuals directly have, perhaps if I'm gonna mention one of them in 2 or 3 minutes, I would mention private enforcement, so private rights of action. I think private rights of action are really important for a statute like the CPPA. They're really important, first of all, for redress, which relates directly to what Teresa was saying about these statutes, whether they acknowledge it or not. They are regulating privacy, which is a human right, and other human rights that are related to privacy, as people have their personal information being processed, for example, the right to non-discrimination. So it is important, first of all, to have private rights of action so that people can find redress when they're harmed. And it is also really important to have them because of enforcement, because it is impossible for the OPC to investigate absolutely all breaches, and it's particularly unlikely that they will do so with the enhanced enforcement discretion to investigate that the CPPA gives them, with respect to PIPEDA, with the changing role from ombudsman to regulator. So I think these private rights of action are, first of all, consistent with related Canadian legislation, right? So they're consistent with the Telecommunications Act, with the Competitions Act, with a bunch of provincial acts that regulate other areas that have similar private rights of action, coupled with public enforcement. And they also follow international precedent, particularly modern international precedent, such as the CPPA, the CCPA. We'll get them confused pretty often today, for particular types of risks, and Quebec's Big CC4. Now, what does the CPPA do with private rights of action? Well, what it does is that it says that individuals can find redress, can get all of this, as long as the commissioner or the tribunal has found a breach of the statute. Now, while I think that, while this might seem minor, I think that this is an enormous problem, because the condition on finding a breach by the commissioner or by the tribunal undermines most, if not almost all, the benefits of private rights of action. The whole point of private rights of action is to allow for enforcement for those situations that may be small and the commissioner may choose not to investigate. So by making it conditional on finding a breach, we have two problems. First of all the things that private enforcement could do for us by filling in the cracks of public enforcement will not happen, because private enforcement is made conditional on public enforcement. And second of all, because there's nothing in the bill that says that fines preempt private rights of action, then the enormous fines that the bill introduces will be doubled with potential lawsuits from individuals or organizations, making the potential liability for companies that are already fined quite highly enormous. So you may be asking, well, Ignacio, you're saying that private rights of action are really important, but then you're pointing out that this introduces some sort of uncertainty for corporations because it may lead to very high liability. How do you couple those two things? Well, there are other ways to curtail the right that are I think, much better than making it conditional on a positive finding from the commissioner. So, for example, you could give, like the CCPA does, a provision that gives companies a certain amount of time to redress an alleged violation, say 30 days before the private right of action is triggered. you could have a provision that says that business legal fees are going to be paid for frivolous claims, or you could have directly a statutory maximum in damages. You could take, for example, the maximum of the Ontario Personal Health Information Protection Act and say that for each statutory breach, then the maximum claim will be $10,000. And what you do with that is that you basically take all these claims to small claims courts, and you reduce incentives to sue unless there's a very widespread violation with very small harms that could potentially lead to a privacy class action. And something like this would be a much more robust, I think, way to approach private rights of action, which meets modern legislation such as Quebec's Bill 64, the Singapore New Act, and the CCPA, and it avoids the problems that the GDPR has with Articles 79 to 82, in which, while it technically incorporates private rights of action, almost none of them have happened. There's very little precedent about them, and the little precedent that has happened on private rights of action under the GDPR have mainly been on local tort law, particularly Dutch and German tort law, that happens to coincide with a GDPR violation, but not based on the GDPR violation, getting into very complicated discussions of what is material and immaterial harm. So I guess that's my main take on the rights of individuals under the bill.
Thank you so much, Ignacio. I have so many comments, but I'm gonna just give the floor now to Eloïse Gratton from BLG to maybe give her to give us a perspective from practice as a practitioner. Thank you.
Sure. Thank you. So first of all, I'm happy that the law remains fundamentally tech neutral and aims to balance the interest of individuals and against those of businesses. I guess a couple of great amendments in a few areas of concern. I'll try to make it brief. So I think the highlight of the bill for me is the new consent exception for legitimate business practices. I was arguing in my PhD thesis a few years back that we have come to a point where it is simply unrealistic to expect consumers to review and understand long and complicated privacy notices. And I was proposing to limit the number of situations in which consent is sought and focus on situations that truly warrant protection. In my view, this is exactly what this consent exception does, and we can tweak it, but at the end of the day, that's what it does. It focuses on business practices that don't go against the reasonable expectation of consumers. And it's definitely a step in the right direction. I've been waiting for this update for 10 years. I see that the Privacy Commissioner has raised some concerns, saying that this consent exception does not specify that such uses are conditional on privacy rights being respected. I think that the fact that this exception does not apply if the information will be used for the purpose of influencing the individual's behavior may address some concerns, but I agree that we may have to think about this exception a bit more and make sure that it's properly worded to address these types of concerns. Another great change in the draft CPPA state that is the one relating to the fact that de-identifying data does not require the knowledge or consent of individuals, clearing up a long-standing ambiguity under PIPEDA. I think this exception would allow businesses to reuse de-identified information for secondary purposes, such as business analytics. So I think it's good news for innovation. One downside is that the definition of de-identify seems to make anonymized information subject to the law, whether or not that was the intention. So I think we need to spend some time thinking about this one. I think it will trigger many challenges in practice. I think in this respect, it's interesting to contrast the approach taken in the CCPA with the one taken Quebec's Bill 64, which provides separate definitions for anonymized and de-identified data. There is also a consent exception for sharing de-identified information for a socially beneficial purpose, but only with public sector entities. So a little disappointment there. I believe that private sector businesses may also wish to benefit from this exception for similar types of projects that may be good for the society. So this is something to keep in mind for those of you who will be getting involved in the consultation relating to this proposal. I think there's a way to do it with the proper framework. The reasonableness test remains, so section 5.3 of PIPEDA becomes 12.1 of the CCPA. And I like this test. The challenge is that this test introduces a lot of flexibility and uncertainty, since the issue of individuals' reasonable expectations can be difficult to assess. So it's a great test, but it's problematic for organizations seeking to launch an innovative product or services. They may not always know exactly where to draw the line. So this uncertainty is also part of the reason why PIPEDA operates under an ombudsman model. So now we have a bill that includes important fines and a private right of action. So I won't lie, this is making me a little bit nervous for some of the large businesses that I advise that will be dealing with this uncertainty when innovating. Last comment quickly on the private right of action, given that considerable amounts may be imposed in the form of AMPs, I question whether it is necessary to include a private right of action. I enjoyed some of the recommendations from Ignacio on this issue, and I realize that it's a more limited private right of action, so it's good, but we still need to keep in mind that there are a number of novel provisions being introduced under Bill C-11. There are many gray zones. And I can't help but draw a comparison with Castle. So recall the private right of action was scheduled to come into force 3 years after the rest of Castle's provisions, but then the federal government decided to indefinitely suspend its effective date, citing difficulties experienced by stakeholders in interpreting several provisions of Castle. So at the very least, the government could consider perhaps delaying the private right of action by a few years in order to properly evaluate whether there is a need for this additional measure to ensure compliance. So that's all I have for now. Thank you, Florian.
Thank you so much, Eloïse, and sorry for the awkward silence just before. Yeah, I think you're making a good point about like Castle, and I think a lot of people are afraid by the number of sections that call actually for regulation to be enforceable, to be enforced. So maybe actually on this, I will invite my colleague, Professor Michael Geist from the University of Ottawa, to share with us his hot takes, maybe about like all those regulations and like the tribunal, etc.
Sure. Thanks, Florian, and thanks to Florian and Teresa for pulling this together. I think it's a good segue, because I think Eloise's comments highlight one of the very first points that I wanted to make, and that is the issues that she just discussed are not the issues, I would say, or at least not the perspective that I've heard a lot from people in the privacy community. And in fact, on some of those issues, they would often take an opposite approach in terms of where the concerns lie. And I think that highlights what I think will be a rough road for this legislation. Privacy feels a lot like copyright to me in certain respects, not from a substance perspective, but the kind of the general approach that people often took with respect to copyright reform was that if nobody was completely happy, you probably had a pretty good balance. And it strikes me as part of this privacy legislation, we're going to, I think, see people from all sides of this identify concerns, oftentimes on the same issue. And perhaps that may be indicative of a government trying to strike a fairly reasonable balance, at least on certain of these issues. I did want to mention the tribunal a bit. I mean, I know that there has been some concern expressed. The Privacy Commissioner has expressed concern. People like Ann Cavoukian have expressed concern as well. I think in theory, an expert tribunal is actually a pretty good idea. The potential to have expert tribunal in place brings in an additional level of expertise that might be viewed by subsequent courts if these cases go through the courts with some amount of deference, although there are, of course, admin law profs and colleagues that know far more about those issues than I do. The problem, I think, with the way the tribunal has been struck, at least in the bill, is that the benefits of it, I think there are benefits of an expert tribunal or expert panel. This is not an expert panel or tribunal. There is, it calls merely for one of the members of the tribunal to have information or privacy law experience or expertise. There can be 3 to 6 members of the tribunal. And it strikes me that the approach really ought to be to try to create an expert body. And one could well envision looking at similar kinds of tribunals in other areas where you would often have a former federal court judge or someone of that nature serve as the chair, given kind of experience on those issues. Perhaps the vice chair could be a former privacy commissioner, whether at the federal or provincial level. And I would have thought that all other members of the tribunal ought to have some level of expertise in the area so that it genuinely is an expert tribunal, more likely to be granted deference on the decisions, more likely to have an understanding and an appreciation for some of these issues. The one other issue that I'll hit on quickly, because we have so many people, are the extent to which some of the big issues and newer questions are left to regulations. And Eloïse just mentioned what we experienced with the anti-spam legislation and how the private right of action was delayed and now doesn't seem like it's going to come forward. She seemed to suggest that's a feature, not a bug. A good thing that it's delayed. I wouldn't agree. I think the fact that we haven't moved forward with that is a problem. And I think that if we look at past experience on what emerged as the controversial privacy-related issues in the anti-spam law, on security breach, the fact that many of the toughest, sort of more granular questions were left to the regulation-making process, which left those that lobby on these issues with a second opportunity to lobby on them, resulted in very lengthy delays. We're talking about years of delays before these rules take effect, I think is a problem. And I fear that on some of these kinds of issues, we are setting ourselves up for similar kinds of at least 2 rounds of lobbying, both on the bill and then and there's of course more than 1 round of lobbying even on a single bill. You get it at the House, you get it at the Senate, but then we'll get it again as part of what will undoubtedly be a lengthy regulation-making process. And I would have been happier to see more specifics included in the bill and less left on some of these issues, less left to the regulations, because I fear it's going to take a very long time before any of that takes place. I'll stop there.
Yeah, no, thank you. I fully agree with you, but like all those call to regulation in the statutes. Maybe I would now invite because we discussed like the tribunal, etc. Maybe we could invite Paul Daly, who is one of my colleagues at the University of Ottawa, an expert in admin law, in the standard of review, in Vasilov, etc. Maybe if you could share his hot takes about what is proposed in CPPA in C-11 on the matter.
Well, I will be uncharacteristically brief, Florian. I agree with Michael that it's a bit unusual to have a tribunal with members who are not required to be experts in privacy law. It's the sort of tribunal which its authority is essentially limited to questions of law, legal questions of principle relating to privacy law, and it would have an opportunity to develop a consistent and clear jurisprudence on the scope of privacy provisions. It has the potential to be a very powerful and influential tribunal because its decisions, when reviewed by the courts, would be subject to deferential review. So it is a little bit unusual that there's only one privacy expert in there. Other than that, from an administrative law point of view, there's not a whole lot to say other than the focus on administrative monetary penalties as a means of ensuring compliance is coherent with the general direction and the policy of economic regulation in Canada and many other Western democracies. Administrative monetary penalties, often running into the millions of dollars, are the preferred way at the moment to achieve compliance. So that's all I'd really say. I second the important point is that I second what Michael was saying about the expertise of the tribunal members, and it would be better, I think, to have a provision in there guaranteeing that the at least a majority of the members are experts in privacy law. Otherwise, there risks losing an opportunity for the tribunal to develop a strong reputation as a developer of norms in this area, a very dynamic area going forward.
No, no, exactly, and also maybe some provision about the composition itself and from which kind of side of privacy those members are coming, because this is something we've been commenting a lot. This is maybe one of the biggest issues, in my opinion, in C-11. And so maybe I would call Alex Cameron. Alex Cameron was from Fasken, another one of the other leading privacy practitioner in Canada. So if you could share with us your hot takes about the bill, like maybe what it means for your clients, etc.
Sure. Firstly, I think it's a reminder that this is a fantastic area to be working in, and that job security for everybody on this call and interested in the subject matter is quite good. So these issues just continue to evolve, and it really is a fantastic and fascinating area to be working in. I think it's nice to have something to focus on and talk about other than COVID and US elections. So, relish that for as long as this continues. I think I agree, of course, with many of the comments that have been made so far. I think nobody's jumping for joy about this bill, but nor is it, from a business perspective, nearly as bad as it could have been. I think most would acknowledge that. There's certainly things to be worked out and lots to discuss, but could have been a lot worse. And there are some things to be happy about it, as has been highlighted already. I think that I just focus a few comments on the enforcement stream in terms of some observations that I think are going to continue to evolve and be discussed, and I just highlight a few of those. One, I thought it was interesting that the commissioner and the tribunal have the power or the statutory ability to take into consideration on the OPC side the size and revenue of the organization in applying the act, and on the tribunal side the ability to pay and the financial impact in assessing a penalty, which I think will present some interesting questions for organizations. It's obviously those types of things aren't going to be helpful for larger organizations, and that can be viewed as quite a problem, actually, that they may be viewed as being held to a higher standard in some respects. But presumably those provisions were in part to temper the application to smaller organizations. But I think it will be challenging for organizations to utilize those factors in assessing their approach to compliance with PIPEDA. It's not a factor that's listed in the appropriate purposes test, although you can look at the cost of your initiatives. But how can you reasonably inform your approach based on your size? So and at the end of the day, particularly when you get to the tribunal, is that going to mean you're going to have to open the books and prove with some evidence that that this has some impact in terms of your ability to pay in revenues? So I think that's going to have commercial concerns for anybody looking to rely on that. And then on the flip side, is that really of a lot of use to the small organizations, and how will the OPC grapple with the potential challenge that if what that means is that a smaller organization would be justified in adopting less rigorous safeguards, for example, or a reduced privacy program, what if they hold particularly sensitive information? Even notwithstanding their small size and revenue, they may hold sensitive information, and what kind of message will that send? So I think it's an interesting concept, and one I can see has some benefits, but I think there'll be some real challenges there in terms of how that plays out. On the sort of inquiry, process and the the tribunal, a few comments. I think firstly, you can only go to an inquiry if your complaint's not resolved or discontinued, and what's resolved. And I can see there's going to be some fights about that issue. Often organizations come to the end of a process with the OPC and agree to take certain measures and would consider that the matter's resolved, but there may be a fight about whether you actually meet the definition of resolved. So I think that one was interesting. Timing, I know some commentators have raised issues about timing for the tribunal. I can see certainly in my experience that more complex inquiries in Alberta in particular have dragged for years. And that raises concerns on both sides, both for individuals who are looking for recourse and also obviously for organizations who have to incur the cost and put the time into those types of proceedings. So much to be worked out on that side. In theory, again, could be a useful piece, but some issues there. Interesting, I thought that the organization can't just agree to pay a fine. So if the OPC makes a recommendation, and perhaps that may be part of a resolution, perhaps. I think there's just a question there as to whether you would have to go to the tribunal to have, in effect, a consent order, and whether that would have implications, or whether you could just agree with the commissioner to pay a fine if you thought that was appropriate. So interesting there. And then I think the other piece that, I spend a lot of time on privacy breach class actions, and often there are parallel proceedings and complaints pending before commissioners. And I think that some of what's developed here in C-11 will have some interesting implications for parallel civil proceedings. We already see that, in civil proceedings, courts have, had regard to commissioner findings in some cases in Ontario in the health sector in particular, but I've really said that they're focused on different issues. I think the ability for the commissioner now to make findings and the tribunal to similarly make findings may change that perspective. We'll have to see, and I think may also introduce some interesting arguments about whether if these remedies are available to individuals under the statute, whether really class actions are an appropriate or preferable procedure for resolving those types of complaints that may be fundamentally complaints about breaches of PIPEDA. So I think there's some interesting arguments there on the private right of action. Certainly share the concern. Again, I would say it's probably not nearly as bad as many might have feared. There's no statutory damages. I think there's a real question about whether anybody could ever prove loss or harm as a result of a privacy breach. That's often the real sticking point for plaintiffs on the civil side, that you can't prove it. It may not be as much of a threat as it could have been in that those things are not there. But of course, there are still the civil claims and the tort claims that can be brought. So those are just a few observations. I think I'm really interested in the discussion, and certainly lots to talk about on many different fronts. So thank you.
All right. Thank you, Alex. And again, like a perfect segue to the next art text. So maybe I would invite Professor Emily Laidlow from the University of Calgary to share with us our text and maybe the implication of C-11, for all the issues we have seen in the news for users on social media. Like what is like C-11 of any help? Is it actually like playing against, like technology facilitated violence and abuses against women, against like trans people, etc.
Yeah, thanks, Florian. Yeah, I've been trying to mold this one. I think I'm in the same boat as many others, where I'm still trying to kind of process through some of the different provisions here. And so let me give you my few big takes from that broader social media security perspective. So I was thinking it through the perspective of, when we engage online with all these social issues, the data flows that we're looking at are complex. They're generally shared spaces, often dealing with publicly disclosed information. And a lot of it too, we're dealing with inferential data too, all that kind of mundane data that's compiled and can create sort of these sensitive profiles about us or can impact us in some way, decisions made about us. So when I look at the new bill, I actually think it's made some really interesting, strong strides, and a lot of it's in line with some of what the other speakers have said. Welcome provisions on data portability, the right of users to withdraw consent, to require that personal information is deleted. But there's some other aspects of the bill that I don't think transfer as easily to kind of those social experiences online. So I think one of the interesting provisions is the obligations on organizations to be, open about automation that makes predictions and recommendations or decisions about individuals. But the way I'm reading it doesn't look like it addresses really the other side that we see with social media, where the organization isn't making use of the automation, but is providing essentially the data to others to use for automation. I'm not clear the way it's written whether something like differential pricing is really captured here. And so when I look at, as a comparison, the California Consumer Protection Act, it seems to just more directly address some of these kinds of issues. The idea that consumers can opt out of sale of their data to third parties, that third parties need to notify consumers if they then want to sell the data, and give the consumers the opportunity to opt out. On a more core level, I think that there are certain things I'd like to see in the bill that are currently missing. And one would be, and this is something that Teresa was talking about, and this was the Rights Foundation. So just in the social media context, I was trying to think through why I thought this mattered so much. And, the influence of the GDPR is kind of obvious when you're reading the bill. But with the GDPR, the data protection is protected as a fundamental right in the Charter of Rights and Freedoms, and they have a lot more kind of contextualizing of their provisions with the various recitals, and we don't have any of that here. And that sort of rights foundation provides the analytical lens to understand data protection and also to make sense of some of the other provisions. So when I look at cross-border data flow, so Section 62 of the Act says that, organizations should be open and transparent, and that they should disclose the cross-border data transfers or disclosures that may have a reasonably foreseeable privacy implication. Well, if this had more of a rights foundation, then this enables organizations to kind of analyze what that means. But at the moment, when I read that, there isn't really much to guide a company. And to my mind, it seems to be trying to complement in some ways what we're seeing in Europe, post Schrems 2, even with the recent European Data Protection Board recommendations that companies really need to analyze foreign surveillance laws. But without that rights foundations, I think it's going to be more difficult for organizations to comply, and equally for the tribunal to assess it. There is an exception still for publicly available information. This existed before. I always have been uncomfortable with that, given the way that we live our lives online. More contextualizing factors would be helpful there. And I think one of the last points I wanted to mention is really just the idea of consent. The bill really strives to simplify consent, but it still is kind of that driving force. In a social media context, the baseline is, what we do is personal information disclosure. And it is a space that is constantly playing, mind games with us. When we get locked into specific platforms, we lose control of the threads of our online stories. And I'm just not sure, I'm not convinced how well consent operates here without more in this bill. Just a couple of the provisions, Section 18.2E says a business does not require consent to collect or use. So it doesn't mention disclosure here. It just says to collect or use data where it would be impractical because there's no direct relationship between the organizations and the individual. But there's a lot of the more pernicious, aspects of consumer data brokerage, for example, is indirect between the organization and the individual. So I'm not satisfied with that particular exception. And the last one would be Section 15.4. It says an organization can rely on implied consent when it assesses that it considers appropriate to taking into account the, reasonable expectations of the individual. When we're looking at these kind of shared technologies, what is reasonably expected of the individuals, I don't think is necessarily a useful lens to look at what appropriate privacy protection should be here. So those are, I guess, some of my few thoughts at the moment.
Thank you so much. And I have, again, so many comments, but I promise I will not start a rant live, so I may wait for the Q&A for this. I will just, we will move to our next experts. I will invite Professor Andreas Lane from the Ontario Tech University to maybe give her thoughts about C-11 and, maybe what Emily just mentioned about the way we might be able to import the charter principle and some quasi-constitutional approach to privacy in C-11.
Yes, thank you. So I think this is a very interesting development in the trajectory of bringing privacy legislation into the sort of constitutional framework. It goes back to the Eastman and Canadian Pacific Railway case, the federal court case from 2004, which sort of set up that 4-part test, which looked a lot like an Oakes test for sort of figuring out when, in that case, an employer was using privacy invasive means of video surveillance for something that's actually quite close to a government type activity, because it was a public safety-ish type thing. So what interests me here is the sort of somewhat codification of that in the section 12 that has already been raised. Teresa raised it, and sort of as part of the sort of rights foundational type implicit approach of this piece of legislation. But it's still got some, wonkiness, partly because it is now trying to apply that type of reasoning to a much broader spectrum of relationships and much more broader spectrum of activities. So in particular, I think there's some things that map really quite easily onto this sort of Oakes type section 1 analysis. Obviously the minimum impairment type things, sort of the least intrusive means, and the proportionality balancing of the benefits from compared to the loss. But the other things I think are a little bit harder to map quite as closely. So I'm curious to sort of see, how much interpretation courts are going to have to do to sort of see how closely, sort of, for instance, legitimate business needs comes to something like a pressing and substantial objective. It's not quite a necessity test, because it's the business's needs that are sort of predominant there, as opposed to something that's a sort of public good that would be normally the kind of thing that you're considering in that type of test. So I think that's some of the things that I think are really kind of interesting to sort of think through. And I'm just, like everybody else, I'm just kind of starting to unpack it. The other thing that I find, again, sort of trying to map these things onto each other that might be a bit sticky too, is the elevation of effectiveness as sort of the only real sort of measure of that type of rational connection thing. And again, that sort of is partly because we're trying to sort of bring these types of concepts into the private sector and into a relationship that's not entirely adversarial, but at the same time is kind of set up that way, where the business and the consumer need to have some sort of mutual meeting ground in order for those relationships to work, but that there's also some tension between the two. And I think that's it for me right now.
Thank you so much. And to complete that round table of some of the few Canadian experts, I would invite Adam Kodash from Oslo to share with us his hot takes on C-11, and especially what I was interested with that event to have also the practitioner perspective, what it means for the businesses with the new compliance obligation. And I think, as Alex said, something that maybe one should be thankful to ISED is the the business coming in for the next years with that bill. Adam?
Yeah, thank you. Sorry, my video isn't working, but thank you for inviting me and thank you for putting this together. I guess I'll offer a few comments and in the interest of time, even cut out a couple so that we can get to the discussion. First, my initial impression was that this was a very thoughtful proposal for a legislative framework. Thankfully, in my view, the CPPA provisions incorporate core themes of the PEPITA statutory framework that, while despite the bashing that statute and its structure has taken, there are core elements to that framework that have served the community and stakeholders very well. There's the balancing of interests. There's rules generally drafted in principles-based, technologically neutral, sectorally agnostic fashion. And for the most part, it seems to have continued in this statutory framework. And fundamentally, the accountability model, which is enhanced, of course, and strengthened, that's been a really important feature for an elegant way to achieve privacy protections, but also practically without some of the prescriptive issues and challenges that you have in other jurisdictions. I want to be a typical Canadian and agree with both Eloïse and Michael, mostly because it's just fun, just sitting on the fence like that. Why not? But I will say the points that both of them raise about the regulation aspects of this are important. That's the most important thing. They're important to consider, and we should carefully consider not just those, but the rules in here are going to be the guardrails, or going to be among the guardrails for the future of the thriving of the success of the knowledge economy. So we should be thinking about all of these things really careful. And when we come to even this regulation concept in there, I tend to agree with Eloise's points. I want to comment one, even though I agree with Michael, especially what we saw with Castle, aside from the fact that Castle shouldn't be used, in my view, as a use case for anything. But I will agree with him on the potential downsides. But I can say that we've had some success, and we saw this with PEPITA's breach notification requirements, where what was required for the content requirements and some of the details in there, what was required was a discussion. And the process for the creation of those rules that ended up in that was the product of a very robust and, in my view, very constructive discussion, I think, that served all folks well. So generally, I'm in support of that approach, and you see it especially with the data mobility or data portability concept as well. There's a lot of very, very nuanced issues that cannot go in a statute. They need to be carefully thought through, or you're going to create systemic issues. You just will. You'll create problems. So they need to be parked. It's appropriate for them to be in the regs, but we got to strike the balance. Michael's dead on. We have to strike that balance. Let me offer a couple of comments on one on the thoughtful piece. We haven't heard yet about the codes of practice. To me, that's extraordinarily welcome concept. In essence, it allows for the way, at least we're thinking about it, is for the establishment of, let's call it, voluntary accountability frameworks that could be layered on to complex data processing activities. And there's a whole different array of types of circumstances where this will be very, very, very welcome. And it will be welcome not because it helps private sector get out of stuff. And this is why the way you framed the question, Florian, so well. It's more about it will be effective if when the devil's in the details, we'll see what the criteria are for the regs, but these will be effective for establishing trust. These will be effective for removing uncertainty and reducing reticence that's unnecessary. So I thought, and we heard about this, I said was talking about this, I said I thought was incredibly thoughtful. And they really demonstrated that they cared to get this right. And there's all sorts of circumstances where if we nail this, and again, the devil's in the details, but if we nail this, this could be something to watch. It's something that could be incredibly helpful, that I think benefits all stakeholders. It's not a private sector versus public or privacy regulatory. This could be a better type of win-win. There's some concerns I have with the current framework, but that's not the issue. The whole thing is the broader way it's framed is excellent. Last point. My friend, consent. This statute is structured basically re-emphasizing, reinforcing the primacy of consent as the authority for processing. My comment and my request to this community on this phone, because this is a key crowd, right? Let's have a thoughtful, intellectually honest conversation about this. Let's do this now. What are we doing? Why is it that consent has to be the default, which suggests that it's the better type of authority for processing? Maybe I'm wrong with the statutory interpretation. Why are we doing this? There is widespread acknowledgement, and this is from privacy advocates, the hardcore, all the way to companies across the board, all over the world. This includes the OPC, about the acknowledgement of the challenges faced by organization obtaining a valid consent in a stunningly complex environment. So why are we doubling down and calling this a consent-based statute? Why can't we go to what the GDPR does and say consent could be excellent? It could be, but it's one of several lawful bases for processing. This act, not only does it do, as I'm reading it, and I think we've got to take our time with this, not only does it double down on consent and reinforces this notion where it's a, quote, consent-based statute, and then reinforces the complete fallacy that actually, once I get information and I check a box, that I actually am protected. Really, like that, it's a fallacy for pure privacy protection. The news is an accountability, right? Why does it do this? Why can't we go like the GDPR where it could be, but there could be other very legitimate basis for authority for processing as articulated in the Act, these so-called exceptions to consent. But they're not exceptions, they're other lawful basis for processing. My comment, but my real request is, let's at least have a thoughtful conversation about why we have to default. And you might say, what difference does it make? We got to future-proof this act. PEPITA had one amendment that says every 5 years it's going to be amended. Let's be honest, it might be another 10, 12 years before we have another amendment. Let's future-proof this for the next 10 years. Now, Adam Kardash will be quiet.
Thank you, Adam. And I think I agree with like some of the things you said, and obviously like consent have been highly criticized. And I think on regulation, I think you put your finger off a good distinction. And like, like personally, I'm okay for some bits to be in the regs. It makes sense, but like to deal with exception to statutes by regs, I'm not sure it's the best way. But I said, let's try to not go on a rant. So thank you, everybody, for sharing your hot takes. And so I will invite everybody to ask their questions in the chat. I've seen some conversation, notably about like admin law and the tribunal. So I'm going to try to pick on some of those comments, and please like continue and kind of vote for your best questions to help me filter all this. But maybe I'm going to try to summarize like some key points, and I will use my position of facilitator to ask the first question. And I think like everybody agrees there is a lot of good things in C-11, and it's very welcome. reset, and I think this is the word that Teresa has used, like it's a full reset of our privacy law framework. And as it's been highlighted, we see that like the government look at GDPR, looked at CCPA. Maybe they looked a bit too much at CCPA because they created the CPPA, which is very confusing. That has confused a lot of people on social media, etc. So might not be the best call. Also to have this as C-11, I know some people have been confused with the previous C-11. So yeah, they looked into the statutes, but at the same time, and they fixed some criticism, notably like some criticism that we had about GDPR, but sometimes we wish they had went like, you know, beyond just like looking at the title, like a kind of right, and maybe like look into the exception. And like several of you were like calling for maybe more a GDPR version of our privacy framework. Of course, I know already that people will like be, but Florian, the Constitution. And I know a lot of the comments on social media a bit like, yes, but federal jurisdiction is limited, for sure, but still like there is a lot within commerce. Even if we just frame this within commerce, we can do a lot. Let's just look at Castle, and not the regulation part of Castle, but like the core of Castle, which obviously maybe was not as well written as C-11. This is another thing that is good. Like it's an actual statute. It's well written. Although sometimes it's so well written, we're wondering why that word was chosen and what it might be hidden behind that word. But like the core framework is the same, and I think like many people have insisted on this. We kept the principle, the PIPEDA principle, were like good. There is a lot to be said, obviously, about consent, but like the remaining is there, and we gave like teeth to the framework, and this is what was missing to PIPEDA. And like as Adam just said, like privacy is also good for business, and not just for business, for the lawyers' business, but like for industry, for corporation. And some companies understood this. Apparently others did not, based on some comment on C-11. But it's good, it's welcome, and I think it was, people were waiting about this. Of course, there is one huge blind spot, and someone mentioned this in the comment, is like, where are the federal political parties? Once again, not surprising. I'm not gonna lie, we're not surprised. They're not covered by C-11. They will not be covered by the Privacy Act. Well, please make me lie, but I'm pretty sure that it will not be covered. And yeah, I'm pretty sure it will never be in the Election Act. So I agree with, I forgot who made that comment. I fully agree with you. Maybe it would have been good, especially following like all the Cambridge Analytica scandal, etc., to have those kind of provision. And so to go on the Q&A, maybe my first question would be for you, Eloïse, and maybe to reflect a bit about, you know, the interface, like how C-11 will interface with provincial laws, not just because of the Constitution thing, but we know that Quebec is in the process of also updating their provincial private sector framework with Bill 64. Ontario launched in the summer a consultation to maybe like create their own private sector act. So yeah, maybe if you could tell us a bit like what do you think will be the impact of C-11 for the provinces, etc.
Sure. So this is the second jurisdiction in Canada to officially propose significant reforms to its privacy framework. We all know that it was Quebec that first introduced in June of 2020 its proposed amendments to its private sector privacy framework, its public sector as well. It's also relevant to note that Quebec's legislator recently concluded its first round of public consultations on the bill C-64, and the bill is currently being reviewed in committee. So it will definitely be interesting to see how the committee will consider the federal government's proposal. some of the issues were raised during the public consultation on the issue of the interoperability between Canadian privacy laws. So if we compare the CPPA and the Quebec Bill 64, Quebec Bill 64 is considerably more onerous and prescriptive, than the CPPA. And just for like a few examples, it does not include a consent exception for legitimate business activities. It requires businesses to conduct a privacy impact assessment in a broad range of situations. It requires businesses to follow a privacy by design approach, includes a right to be forgotten, includes very stringent requirements for cross-border transfers, and so on. So the Quebec privacy regulator has favored a broad interpretation of its jurisdiction over businesses that are also subject to federal privacy laws. So the concern is that these numerous differences may raise a number of challenges from an interoperability, sorry, I have a difficulty saying that word in my second language, interoperability standpoint for businesses operating at a national level. So the federal proposal may very well set the tone and become a source of inspiration for other provinces preparing their privacy law reform. So we can think of BC, Alberta, and perhaps even Ontario. And as for Quebec, I'm crossing my fingers and I'm hoping that it will encourage the government to, at the very minimum, revisit the onerous and unrealistic cross-border requirements.
Thank you. Maybe Teresa, would you like to comment also of this, of maybe what it means for Ontario, for BC?
Where am I? There I am. Yeah, I just wrote a piece yesterday or today, I can't remember, it's all a blur, on what this means for Ontario's process. Ontario is in the process of consulting on its own private sector data protection legislation. It's always hard to tell whether, what the motivation for that was, whether there, this was motivated by a real desire to sort of strike out in a separate Ontario direction with respect to data protection laws, or whether it was meant as a very hard nudge to the federal government to, could you please like amend PIPEDA because it isn't, it's not doing the job it needs to do to encourage trust in the digital economy. I think there's still an argument to be made for Ontario to move forward with its own private sector data protection law. I think if you'd asked me maybe a year ago, I would have said, I would have favored the idea that we already have a complex privacy regulatory framework with a real proliferation of public and private sector and health sector data protection laws, and some private sector data protection laws at the federal level, some at the provincial level. And the last thing we need is more complexity within that context. But I think that I'm now shifting towards this idea that there is space in Ontario and perhaps a need in Ontario for its own private sector data protection law, notwithstanding what's happening in the federal law. And I think there's a lot of good stuff in the federal law. And that's in part because of the gaps in coverage left by the jurisdictional divide between the feds and provinces. So there are some things that PIPEDA is never going to cover that a provincial data protection law could cover. There's also, I think, reflected in the changes being in Bills C-11, there is a perfectly legitimate concern with some of the data practices of large corporations that are having very significant effects on people. And so there's a lot, particularly in the reinforced enforcement provisions and so on, that I think is oriented towards addressing some of the larger players in the data economy. And in the provincial context, I think you deal with a much broader diversity of organizations, particularly a lot of small and medium-sized enterprises that have very different data collection practices and data and needs in terms of, and right now, obviously, significant financial pressures. And so I think there's an argument to be made for provincial legislation perhaps being a bit more flexible in terms of integrating some of these smaller businesses. On top of that, there's also the potential for having better integration of the provincial health sector, public sector, and new private sector data protection laws into something that's a little bit more seamless and interoperable for players in the information economy within the province. And so, where you have public-private partnerships or attempts to collaborate, and you could have something more seamless going on. So I do think there's still an argument to be made for provincial private sector data protection laws. Obviously, what happens in Bill C-11, because of the substantial similarity provisions, will set the tone for what happens at the provincial level. But of course, there's also nothing to stop provinces from going beyond what Bill C-11 does, or for tackling particular issues in their own way that is substantially similar. So I think it'll be very interesting to see what happens in Ontario now. BC was looking at reforming their law, and will be interesting. This will obviously have an impact there as well. And I know in Alberta there have been calls for update and modernization of the Alberta legislation. So I think that this is just going to spur some more interesting activity to watch at the provincial level.
Yeah, thank you. And I was looking at the comments and the conversation in the chat to try to find like some question to ask. They seem to be like beyond the tribunal, and like, why don't we use federal court judges? I'm guessing it's a cost issue. Why don't we just refer to the federal court? Maybe that would be a good solution, or like something that I think, I don't remember if it was Adam or Alex who highlighted that maybe we would not require organization to go to the tribunal directly. If they agree, sometimes they would agree that yes, they did something wrong, and like, let's find an agreement. It might be better for everybody, including for the businesses, to have that option where like they could accept a fine from AMP, from the commissioner. So like, a lot of things to think about for everybody will be like in committees and for people in the government. But like, to go back to the consent, and maybe I would invite like the expert to raise their hand if they want to enter those comments. There a lot have been said. Some people were asking if maybe we should treat the companies as information fiduciaries rather than relying on the consent framework that has been highly criticized. Would that be more like practical, more useful? I don't know, maybe like if Michael, Ignacio, or like Alex, you would like to give your thought about the need to maybe look beyond just the consent, and maybe like on all those exceptions that are like provided for in C-11, and sometimes they, as I think Adam said, they're more like just other basis than just like an exception to the principle. Michael, yeah.
Sure, I'm happy to jump in just by noting that I think the discussion has been a really interesting one that I think also does highlight how there is a bit of a gulf on exactly these kinds of issues, on the appropriateness of consent. I mean, Adam's incredibly articulate, and so makes his case for why there should be a good conversation about whether or not there's value in rethinking some of these models in certain circumstances. I saw others in the chat that were just quite clearly weren't going to have any of it, and I think that does point to what is going to be a significant challenge, not even leaving aside the regulation side of it. Just right now, there are rumors this is going to the ETHI committee, not even the Indu committee, which I think is interesting. If that's what happens, I think certainly people from the commercial side of the privacy issue will have some concerns, given the makeup of the ETHI committee and some of its perspectives in the past. So it feels like a bit more of a home court environment, perhaps, for those that have strong views on things like consent models and the like. But, regardless of even where it goes, I do wonder, I mean, candidly, in a minority government situation where the MP or non-expert MPs will be either told This is a disaster for business because, notwithstanding the great expertise that we have on the call, we all know that representatives for small business groups and other groups are going to say this is going to be an absolute disaster at the very time that the economy is struggling. And then hear from privacy groups saying you haven't addressed the core elements of privacy. If anything, you are weakening it. And I do wonder how that shakes out in a politically sensitive environment, and whether or not, if we're honest about it, the government is going to be willing to expend the political capital necessary to even address the kinds of questions you've just raised around, the exceptions and changing consent models.
Thanks. Ignacio? Maybe?
Hi, yeah, thanks. So I agree with Michael, so I think this is a conversation largely about what law professors call rules versus standards. So do we think that privacy is adequately protected by setting up things that are allowed or disallowed in advance? Or do we think that the ways in which people are harmed through their personal information are complicated and hard to anticipate, and therefore we want rules that operate exposed? And information fiduciaries are perhaps the most robust of the rules that operate exposed, while consent to give control is the most robust of the rules that we can have ex ante. So consent, for a number of reasons, doesn't always work, and Adam explained that quite clearly. And I mean, it can be summarized as people don't read privacy notices. When they don't read them, they don't understand them, and when they do understand them, they change all the time. So they're useless to a large extent. That doesn't mean that there's no room for consent. I think that means that while there can be certain situations in which consent can effectively protect people, because people can privacy self-manage, they can consent to the things that are good and not consent to the things that are not good. That is not a holy grail for privacy. So it's important to have mechanisms like information fiduciaries or liability rules that can catch those things. Now, the interesting thing about this bill is that while the government has presented it as a bill that will enhance Canadians' control over their personal data, it actually reduces the centrality of consent compared to PIPEDA, as Eloïse was explaining, with the legitimate interest and with a very wide public good exception, with quite a wide research exception. I think this is a good thing, as long as that decrease of the importance of consent comes coupled with guarantees, with things such as information fiduciaries or liability that will catch the things that consent was supposed to catch but didn't.
Yeah, no, I think you put your finger on something important. Or like, it's not that we're like fully against, like some of the exception which might be like necessary, like for the social good kind of social good AI like exception. It's a good idea. Maybe it doesn't go far enough, as Eloïse said, but at the same time, we might need like some safeguard, maybe with a control from the commissioner, etc., to make sure that it's not like abused, because we've seen like some bad thing happening across the globe. So I'm still like looking at the question, and one that I think is quite interesting, and that was directed to Adam and Emily, but maybe like others would have a say. So someone was asking, what is your take on like the proposal and maybe the consideration for collective rights for misuse of personal data that's not like addressed in C-11. There is not like a right to class of action, blah, something like this. Would this be relevant in the context of targeted advertising, social media, algorithmic decision making, etc.? Maybe Emily or Adam.
Florian, can you do me a favor? Yeah. Just repeat the beginning part of the question. I caught the tail end, but not the beginning exactly.
I'm sorry. So the question was like, do you think there is room for to update like our framework for consideration of collective rights for misuse of personal data? This is not something that's like already addressed in C-11, and so maybe to have your take on this.
So let's unpack that. There's some different elements. So first of all, in my view, and let's use digital advertising, because I think social media itself, which is very worthy of discussion, it has its own set of baggage that we should just leave just for a moment. The statutory framework sets out, in my view, pretty thoughtful approach, set of principles, especially if you were to invoke the code's practice to establish an accountability, tailored accountability structure for a complex data ecosystem that would breathe life to all the principles within the Act. With my one caveat, we just got to tweak the consent thing a bit. And I say tweak because folks, I want to be very careful about, because I've been pilloried for this before, but I don't mean to devalue the value of consent in limited circumstances. What I'm saying is when you get into complex data ecosystems, sometimes it just doesn't work. Like it just doesn't. And by the way, this is not just, forget about what I think. I sat on an advisory, federal government advisory for the automated vehicle, where very thoughtful process with different policy streams. And I happen to be one participant in the privacy policy stream for the automated vehicle. And what was the overwhelming consensus? It was clear that if we were going to thoughtfully create a trust model for the automated vehicle sector, that a code of practice was the way to go. A concept of us individually taking advantage of, well, we don't understand all the benefits of the immense amount of data flows that will happen with the billions of sensors, et cetera. 9 or 10 years from now, it's going to be amazing for us. It's not going to be about a consent regime. That's not going to be it. It's not going to work for us to avail ourselves of the benefits. So no difference from digital advertising, swap out data-rich payments. All of that would be covered in this. I would be very careful with the concept, just for discussion, about collective rights. The statute is structured for the concept of personal information about identifiable individuals. There is certainly need of discussion regarding the concept of ethics. One would think that concepts of ethics can be incorporated by implication into like reasonable, appropriate, like you would read in if something is unethical and how could it be appropriate, right? Like, so along those lines, I don't want to simplify it too much. Lots of thinking has to go there. We got to be careful. But I think the regime generally sets out a thoughtful framework. You know, there's some tweaking to do, and I want to pick up on some of Alex's points earlier on. I do think we need to blow out some procedural fairness pieces as well. Let's be careful of making sure it's fair to organizations. But I think there's plenty of structure in this current statutory framework to address egregious activity by an actor with some tweaking to the structure.
Thanks. Emily?
Yeah, I was sitting here thinking that I don't have a very good specific answer to this question because it's all the really big issues that seem really hard to control and sort of shape into kind of a specific domestic piece of legislation. Like the part of what I think about is we can't solve all the problems that we're facing in this area with one piece of legislation. And so one thing I've been struggling with is to the extent that some of these issues even belong in this kind of legislative framework or need to be dealt with in other ways. Adam makes some really interesting points that, you know, I was kind of noting down as he was talking, because it's themes I've been reading a lot elsewhere too, which is, you know, the idea of trust, the idea of building ethics into this space. And so in some ways, I think that the answer here is going back and looking at, you know, what are really the persistent issues that we're seeing with some of these bigger ecosystems, and what does privacy responsibility look like? And what are the right ways and frameworks that we maybe want to start pushing that forward? I would like to see maybe more carve-outs for consent, but I wouldn't be jumping in right now with the right drafting language to be able to address that, because I think that we need to kind of look a little bit closer at what it is that we're trying to achieve. And so I think that's a really hard conversation to have. And I think sometimes that's about, you know, like some of these developments that we're seeing about these certification schemes and these codes of practice are fantastic, because these are more innovative ways that we're going forward that can be a bit more bespoke about kind of crafting them. I, though, as I sit here, think, okay, I like that idea. Does that scale to these bigger issues? I don't have a good answer for that right now.
Yeah. Thank you so much. And so I'm seeing like so many conversation in the chat, but so we're running out of time, and I know we all have like classes, meetings to go. So maybe just to complete that event, to end the conversation, I would add our expert still on the line to give their text. Like, do you think that bill actually will go through? With everything, and notably, like Michael, you highlighted like all the, this is a minority government, there might be a lot of lobbying against. Do you think we're gonna see something happen, or are we gonna get stuck with bipeda for like 5 more years? Just like quickly, yes, no. Michael, maybe to start with you.
I would say, I can't say that I'm optimistic this is going to pass in the current parliament. At the same time, though, I think it was very important to get this out the door because I think it establishes a baseline for reform, so that even if it doesn't become law of the land, and as I say, I think it's going to be a challenge. I think that it becomes the starting point for reform for whoever for the next government, if that's where we find ourselves. And I think it's now firmly placed on the agenda with some real language, which is itself a big step forward.
Perfect. Alex, if you're still with us.
I am, and I agree with Michael. I'm not optimistic either that it's going to go through. Obviously, there are some, incredibly more pressing priorities currently, so it's hard to see that this is going to be a high one. But I do agree that with the momentum having been established and this having been introduced, it will likely form, the floor of what the discussion will be at whatever point it may have a chance of actually getting through. So,
perfect. Thank you. Emily?
I don't have too much to add to what everyone else has to say. I'm actually on the fence. I don't know if this is going to go through. I'd love to see some, significant amendments to it. I think good points were made today. Whether those will be taken out on board and whether those will sink it, I don't know.
Okay. I think we all have the same answer, but just in case. Ignacio, a more positive take, or?
Yeah, I mean, I'm no expert in parliamentary proceedings, so I don't know how much my opinion is worth, but I'm somewhat optimistic. I think it is not surely, but it is not unlikely that it will pass. I think there are a number of factors such as, even though it's a minority government, it's a government bill, there's pressure for Canada to maintain adequacy status, and this won't last forever. And there's bipeda is grossly inadequate in a number of areas, including regulating AI. So I think these factors lead me to some optimism that this may pass at some point.
Perfect. And last but not the least, Teresa.
Thank you. Yeah, I mean, there are obviously some real challenges for this bill to pass in the current context. That said, something has to happen. Something needs to be done. PIPEDA is in need of reform. And there's, without question, there has been a tremendous amount of work and thought that's gone into this bill. And it's not perfect, and we can all point to things that maybe we'd like to have, that maybe should be different, or that we'd like to see different. But the bill does reflect a tremendous amount of work and effort to come up with a viable, credible data protection law for Canada. And so it, at the very least, makes an excellent starting point for the reform that we need to enact at some point.
Yeah. No, yeah, thank you. And I think, Ignacio, put your finger on something important, the adequacy test with GDPR. And I know this is basically when you read, and sometimes like you see some section like, yeah, it's there with so many exceptions, but they just want that to be in the statute to show to the EU at the next inquiry that, oh yeah, we know of this in our federal framework, we can pass the GDPR adequacy. Would they pass? Maybe like the private right of action. Not sure it would pass as it, but yeah, I think it might be what will save the bill, because businesses, even the small businesses, they need this, especially in the digital economy. So on those words, I would like to thank again all our experts, all our attendees. I think it was like a wonderful conversation. We're gonna upload the video on YouTube. Some people were proposing in the conversation, maybe, yeah, we're gonna write like maybe a short brief, but that will be just the beginning of the conversation. Like there is so much to discover, to look into between the sections. And that's actually just the first of several events. Maybe it's also my new business, C-11 panels. Next week, la semaine prochaine, 1er décembre, 11h30, un événement français. So we will do the same, not with the same people, with other experts that time, so in French, commenting on C-11. And I'm sure that in the new year, we will have more like focus panel, like I think there is a lot to be unpacked with the consent and the exception, with like AI, all those new exceptions, like the identification, or do we scope out or not those kind of data? I don't think we do that right now, and I don't think we should, but there is room for conversation, all the new exception and all the new rights, like for example, the kind of right to an explanation for automated decision that we find-ish in CPPA. So yeah, so more to come. Thank you everybody for your attendance, and thank you again to our wonderful speakers. Have a nice remaining of the day. Bye-bye.